Hi, I'm Max Majeski, MJM Law Office here in Eugene, Oregon, and today I'm making a video about what to expect at your Oregon criminal arraignment. Now, I've been wanting to make this video for a while because of all the things that happen in the criminal system, people get really stressed out about what's going to happen at the arraignment. This isn't really for career criminals or people that have been through the system. This is more for people, if you've been arrested for a crime, first time, don't know what to expect, you're issued a citation. On the citation, it has a date and an address of a courthouse where you're supposed to make that first appearance. And so the questions I get is people just don't know what to expect. I get calls of people that think that's their trial date. I get calls from people that think they're going to jail. I get calls from people asking me, should I plead guilty at my arraignment? And so I just wanted to take the time to answer a few of those questions. And no, you should never plead guilty at your arraignment. So basically, the arraignment is kind of a historic court date that goes way back in time to English common law before most people were able to read and write. And it's an opportunity for the court, the judge, to tell you what you're being charged with officially. When you're out and you get a DUI or driving while suspended or whatever it might be, and the officer writes you up a ticket, well, that's a citation. That's not a charging instrument. That is something that's going to be sent to the district attorney or city prosecutor along with the police reports, video, other evidence. And then it's up to that attorney, the district attorney or city prosecutor in a municipal court, to review all of that and make the filing decision on what you should be charged with. And so when you arrive at court on the date of your arraignment, typically you'll be given a document called a complaint, or in Lane County Circuit Court, it's called an information. If it's a felony and it's gone through grand jury, it's called an indictment. But whatever the case, it's the charging instruments. State of Oregon versus so-and-so, this is what you're being charged with. And it has to say specifically, what happened and why you're being charged with this. For example, on a DUI, it'll say something like, count one, driving under the influence of intoxicants, that on or about such and such date, you drove a motor vehicle while under the influence of intoxicating liquor on a premises open to the public. And so it's just a blip of information basically showing what the city attorney the city prosecutor or DA thinks you should be charged with. And so that kind of really kicks off your criminal justice court process. So typically, on that day, if you can't afford to hire a private attorney, you would fill out the paperwork to apply for a court-appointed lawyer. That's a financial affidavit documenting your income and assets. And if you qualify under a certain threshold, then at that time, the court would appoint a lawyer for you. Usually we get cases, I'm a private retained attorney. People usually call me, hopefully before their arraignment date so that I can appear at that arraignment for them. If it's a misdemeanor, you don't even have to go to your arraignment. If you hire a private lawyer, we could file a waiver of appearance and I can appear for you at that first appearance date. And really the purpose is just to notify you of what your legal rights are, that you have a right to a lawyer, right to trial, right to call and cross-examine witnesses. It's to make sure the court has the right person. So they're gonna verify, is that how you spell your name? Is this your correct date of birth? Just a real kind of procedural thing. It's a real brief hearing, usually just a few minutes. You're in there and you're out of there. And then you have your next court date. And so that's really all that happens at an arraignment is typically you're told what the charges are. And then some courts take a plea. If they want a plea, you'd enter a not guilty plea. That's how, you would start your case, set your next court date so that your attorney could get and review all of the evidence. And then you go back for usually a status hearing about 30 days out, and that's where you're gonna go back and say, hey judge, do we need more time? Are we gonna set it for trial? Are we gonna, do we have some deal worked out? Something like that. What are the risks at your arraignment? Well, the court might want you on a release agreement, so that's one thing. If you were just cited and released and then given an opportunity to come back to court on your arraignment date, some courts will want to sign you up on a release agreement, maybe post some bail or bond at that point to make sure that you're going to come back to future court dates. But typically there's really not much chance that you would be taken into custody on the date of your arraignment on a citation that's having you appear in court. So I wouldn't worry about that one too much, and I wouldn't worry about pleading not guilty. Some people say, well, I did it, why would I go plead not guilty? Well, you don't have the information to go in there and plead guilty. You're not gonna be ready to be sentenced at that point. The judge isn't gonna just you don't want the judge to just sentence you open to the maximum penalties. And so it's just really a procedural thing where you go in there, you find out what you're charged with, set your next court date, and then we start getting all the evidence, reviewing the case, and go back to court. So that's, really the primary basis of an arraignment. It's not something to get too worried about. It's not your trial. You're probably not going to go to jail. And if you want a court-appointed lawyer, that would be the time to apply. So hopefully that video was helpful. If you do have a criminal charge that you're being arraigned on and it's in the Lane County or surrounding areas, give us a call. This is Max Majeski, MJM Law Office. Until next time.